and they were all lumped up together. You have petroleum communities, trust fund. You have a downstream sector of petroleum. Downstream means the distribution. Then upstream means production of petroleum. All of them were lumped together. Ideally, in legislative drafting, every legislation deals with one subject matter. It's a rule in legislative drafting. So you don't mix two subject matters under one heading. That's the rule of legislative drafting. So you would have the principal subject that a law or legislation is dealing with, and you deal with that. In another legislation, you can deal with taxation related to petroleum. It's a different subject matter. You cannot use one petroleum legislation to deal with taxation from petroleum, regulation of the administrative regulation of petroleum. You cannot mix the two. That is a rule of legislative drafting. In the common law tradition, it is only in the civil law tradition, France and other civil law jurisdictions, they have their laws are called codes. So when you have a petroleum code in a civil law jurisdiction such as France, under the code, a code is a single exhaustive treatment of a subject matter. Chapter 1 of the Petroleum Code will tell you petroleum taxation. Chapter 2, petroleum administration. Chapter 3, petroleum host community trust fund. Until you reach chapter 100. Each of these chapters could be one page. That is the way laws are drafted. In civil law jurisdictions, France and all the other European countries. But in common law jurisdictions, no. Each legislation must deal with one subject matter. You have petroleum taxation, different. Petroleum administration, different. Downstream administration of petroleum, different. Petroleum host communities trust fund should be a different legislation. That is the rule of legislative drafting in common law jurisdictions. So the reason is in the substantive provisions. That is where you state the substance of every law. It's just one section, one clause. And that's where you establish what is the substance of this law. So substantive provision is where you establish the rights, the obligations, the privileges relating to that subject matter. What is the subject matter of that legislation? If it is petroleum, so you write, there is established a petroleum taxation scheme. That's the substantive provision. But if the legislation is to establish a government agency, a statutory corporation, then you state it under the substantive provision. There is established the Nigerian National Petroleum Corporation. So that sentence is your substantive provision. If the legislation, for example, Cyber Crimes Act, there is established a legislation for regulation of cyber crimes in Nigeria. That is your substantive provision. Substantive provision is that provision that deals with the substance of the legislation. And ideally, every legislation should have one substance, one subject matter, not two. Not two. So it is there you establish. It's always the word established is always used when you're drafting substantive provisions. There is established the Nigerian Petroleum Corporation, a body corporate with perpetual succession. That's how it's drafted. If it is to establish a legislation for penalizing, regulating cyber crimes, you state there is established a cyber crimes legislation for regulation of crimes committed within cyberspace. That is your substantive provision. The substance of that law, under your substantive provision, that is when you state it. Now, remember I said principal provisions have two subheadings: substantive provisions and administrative provisions. Now, administrative provisions only arise if the legislation is establishing an agency of government, a corporation of government to administer. So it is if there is an agency that would administer that legislation, then you would have administrative provisions. Now, the assignment I gave you is somebody drafted the Widowhood Leave Bill, seeking to grant leave to widows, spouses who are widowed. Now, the drafter, to show you that they are not experts, they introduced the penalty shall be imposed by the regulatory agency under that bill. However, they did not even name the agency. They did not name the administrative provisions. Remember the rule of legislative drafting, the mongoose principle, and the literal rule of interpretation. Anything that is not expressly stated in the law, the courts cannot give effect to it. So, the drafter of that widowhood leave bill, having mentioned that there will be a regulatory agency to enforce this widowhood leave, the drafter has failed to provide the administrative provisions. How will this regulatory agency function? You can't leave it to chance. That is where you, as a qualified drafter, you now know that once any law establishes an agency, then there will be administrative provisions to state how that agency would be administered. So the administrative provisions state the procedures for administration of that agency. Nothing is left to chance. Who should be the chief executive of that agency? It's stated. The tenure of office, how many years, is stated there. How to remove such person, the governing board, the meetings of governing board, everything is stated inside or under the administrative provisions. Nothing is left for chance. Even how monies are spent by that agency, there is a section of the administrative provisions that are called financial provisions. How monies are spent, annual budget of the agency must be submitted to Parliament by September 30th every year. So it's not a joke drafting any law, especially any law that, although they are there on our platform. So Oscar has posted what are substantive provisions under the principal provisions. Now, Oscar, please post the components of administrative provisions. There are so many. There are so many. You don't leave anything to chance. In Nigeria, Section 14.3 of our Constitution says, whenever you establish a federal government agency or corporation, the governing board shall be made up of six members representing the 6 geopolitical zones of Nigeria. We have the south-south, southeast, southwest, northwest, northeast, north central. Nigeria has 6 geopolitical zones. So whenever a federal government agency is created, the drafters of the administrative provisions are supposed to write there that the governing board shall consist of a representative from each of the 6 geopolitical zones in Nigeria. So it is a very detailed work if you're drafting a bill to create a bill that creates a government agency. Important. I don't know whether in the Kingdom of Lesotho, if there is a requirement that every government agency must have a representative from the 10 districts of Lesotho. I don't know if that's a requirement of your constitution, but in our constitution is a requirement, section 14.3 of the constitution. We call it the federal character principle because Nigeria has 6 geopolitical zones. So every federal government agency, there must be a representative from one of these 6 geopolitical zones. Please, somebody from Lesotho, please, can you confirm, do you have such arrangements in your constitution?
Requirement
Yes.
in the constitution. I could have overlooked, but I don't think like that.
Maybe it's just Nigeria because of our, into section 14.3 of the constitution. So that feel cheated, federal government agency, one representative from each of the 6 political zones is put as a member of the governing board. So it's a unique feature of the Nigerian constitution. So look in the chat box, you see the components of administrative provisions. They are very lengthy and you cannot leave it to chance. You have to draft each component because in the event that there are crises, conflicts, the law would have settled those conflicts. I'll give you an example, real life example. We have an institute in Nigeria. The law establishing the institute, we call it the National Assembly Institute for Legislative Studies. When the drafters drafted, they created the office of Director General, which is the chief executive officer of that institute. However, the drafters did not specify the tenure of office. They only stated 4 years in the first instance, another 4 years. They did not specify whether after 8 years, cumulative 8 years, whether a Director General can still be appointed for another term of 4 years. And because the drafters did not specify, the law now allowed the incumbent, she has done 8 years, yes, coming. She had done 8 years, she continued another term of 4 years. That is to make it 8 plus 4, that's 12. Because the law did not stop her. In other laws, in other agencies, the law says after 8 years, such a person can no longer continue as Director General. A new person has to be appointed. But because the drafters of this law failed to specify, the person continued. It took the amendment by the National Assembly before that tenure had to be stopped. So that is the kind of confusion you can create when you draft without specifying the administrative provisions that apply. There's a lot of case law. If you read under administrative law, a lot of case law, because of not specifying the procedures. Go online, you see the Court of Appeal decision in, there's a case law of Commandant EFCC Academy. EFCC is Economic and Financial Crimes Commission versus the federal government. It is a real life case. The commandant of the EFCC was removed without following the laid down procedure in the law. The law says only the governing council of EFCC can make a law, a subsidiary legislation to remove the commandant. But because the former chairman of EFCC wanted to get rid of the commandant, he made the governing council to pass the law, no problem with that. However, that law was not gazetted before he sacked the commandant. And the establishment law says every law, subsidiary legislation passed by the governing council of EFCC has to be published in the Gazette before it gains force of law. Now, failure to comply with that administrative provision has rendered, the Court of Appeal said, it has rendered useless the sacking of the commandant of EFCC. So administrative provisions, you need to pay attention to them. Check the chat box. You see, even the financial provisions under administrative provisions have to be complied with. In some laws, you cannot give gifts or receive gifts, especially for the Code of Conduct Bureau, all those agencies that monitor corruption. Their officials are not permitted to give gifts or receive gifts. These are part of the financial provisions to stop people from corrupting the officials. So these are provided under the administrative provisions. Very detailed work. So I want us to go one by one. I'll call on you. You read under administrative provisions, you read the A, the B, the C, and explain to me what you understand from there. So Ebenezer, can you call on each person to comment? It has been posted in the chat box. So administrative provisions established. Yes, can you call on somebody, each person? Under administrative provision, there's A, B, C, D, all the way to F.
Okay, sir.
Yes, call on them to comment on A.
I will start by asking people to just volunteer before I call your name. Hello, can we have a volunteer on your own? Okay, in the absence of any volunteer, sorry about the background noise. I am at a workshop. I'm not in my office, please. Okay, so, okay, there's a volunteer. Yes, Madam Grace, please, go ahead.
It's not Madam Grace, so. Good afternoon, everyone.
This is Amino now from Port Harcourt, right?
No, from Abuja, sir.
Then I've been mistaking you for someone else. Sincere apologies, please.
Okay. It has been a very pleasant There's no problem.
Go ahead. Give us. Yes.
Okay. Administrative provisions establish statutory corporations are introduced with care. I think we're told to give an example of the establishment. My example is there shall be established the Legal Aid Council, which shall be a body corporate with perpetual succession. It shall then themselves it shall have a governing board. No, I think it should start with, maybe I should just say the one I can remember off heart.
Sorry, are you with legal aid?
Yes, sir.
Okay, go ahead.
Okay. Okay. I don't know how to count the one for the director. Okay, there shall be a director general. There shall
Okay,
be
thank you for the attempt.
there shall be a governing board which shall be composed of 12 members, a representative each of each geopolitical zone, a
Okay.
representative of the NYSC, a representative of the Human Rights Commission, a representative of ICPC, and a representative of I think that's as
That's a
far as
fair
I can
attempt.
remember, sir.
That's a fair attempt. Thank you.
Yes, sir.
Any
I'll do better
any
next time.
other volunteer? Any other volunteer?
Or should
Okay,
I still keep trying?
let's give other people opportunity
Okay,
too.
sir.
Okay. Madam Shetak, are you here? I have seen you. Can you give us example? I believe you
I'm here.
know why I'm calling you,
Sorry, I'm on the
so
wheels. I
that you
can't
set the tone
exactly
for
go to the
others.
chat box.
Eh?
Can you hear me? I'm driving.
Hello?
I can't exactly go to the chat box. Can you hear me, Ebenezer?
Yes, even though it's breaking. Okay.
I said I'm on the wheels.
Oh,
I'm
oh, oh, oh,
driving. I'm
oh, oh,
driving.
oh. Okay, okay, noted.
Yes.
It's okay. Let me look for another person who's in practice. Madam Uju, please give us an example. Thank you. Joyce, I will come to you. Joyce, your hand is raised. Okay, let us take Joyce. Joyce, give us an example. Madam Uju after Joyce.
It's actually a question. I think I'm lost.
Okay.
I
Ask your
thought
question,
Prof
please.
wanted us to read through the chat and explain how we understand the components of the administrative provisions. I did not get the part about giving examples. I don't know. Maybe I'm lost.
Okay, so somebody has dealt with A, component A under administrative provisions. You can speak about component B. What is it? What does it mean to you? How do you understand B? B says delineation of the powers and composition of the governing board of the statutory corporation and mode of appointment and termination of appointment. Federal character principle in Nigeria. Do you even understand this? What it's saying?
Prof, I think it means the powers that are given to the governing persons according to the statute, what the statute confers upon the people who are in power, and their appointment and termination into the office or into the positions.
Exactly. You have answered the question. I like when you use the word confer. The purpose of legislation is to confer power, especially the administrative provisions. You can only exercise power that has been conferred on you by legislation. So it is when you are drafting, as a drafting lawyer, you have to confer one by one the power you want the person to administer. And this is where you don't create confusion between the governing board and the chief executive. There should be no clash of power. The governing board exists to supervise the chief executive. So you must lay out their powers. Otherwise, if you don't lay out the governing board's power, you create confusion whereby some governing board members who are ambitious will start performing day-to-day task of officials of the agency. That's why we use the word, the choice of word, delineation. Do you know what delineation is? An architect, when you see an architect drawing a building plan, delineation is an architectural word. Where the bedroom will be, the door to the bedroom, demarcates the bedroom from this living room. So that's delineation. There's a boundary. The bedroom is different from the sitting room, except you have an open plan. But delineation means you create the boundary, you delineate. The power for the governing board is different. The powers for the chief executive is different. Otherwise, you create a situation where, humans are always ambitious. They say power corrupts, absolute power corrupts. So if you do not, in the legislation, under your administrative provision, if you do not delineate, separate the functions, confer the powers on governing board, confer the power on chief executive, separate powers, separate duties. If you fail to delineate this under your administrative provisions, you have created problem. You will see them fighting each other every day. One of them would say, this is what happens in the Nigerian police. The Nigerian police created our constitution, not even the constitution created the Inspector General of Police is an office in the constitution. It also created the Police Service Commission. The Police Service Commission is like the governing board of the Nigerian police. So there's always this fight. In fact, 2 years ago, our Supreme Court had to mediate between the Nigerian Inspector General of Police and the Police Service Commission. 10,000 constables were to be recruited into the Nigerian police. The Constitution did not say specific. It says that power to appoint constables belongs to the Police Service Commission. However, the Inspector General of Police wanted to conduct the recruitment. So the matter ended up in court. The Supreme Court held that only the Police Service Commission can conduct recruitment of constables into the Nigerian police. So this is where the problem is. As a drafter, you have to specify, delineate the functions, the powers of each person you name inside the law that creates that agency. Otherwise, do not assume that, people will behave themselves. They will know to mind their own business. No. The nature of human beings, power corrupts. Absolute power corrupts, absolutely. So if you do not confine their powers of discretion, you have given them license. They want to do things that were not expressly stated. That's why that choice of word, delineation, this is where your power stops. This is where the next person's power begins. Everybody knows their functions as spelled out in the legislation. So if you look at what we posted on the chat room, even on your platform, sections 3 to sections 30 of the Nigerian Communications Commission Act. Should the chief executive do? What should the governing board do? Their functions are different. Nobody is encroaching because the law has specified the functions of each administrative official. In fact, if the procedures are too long to put inside the sections, you banish them as schedules. A schedule is always linked to a section. If you look at this Nigerian Communications Commissions Act, it has a schedule for the procedure for board meetings, how the secretary to the board needs to notification for meeting, everything is specified in this schedule. Schedule is like an appendix to the law. When the details cannot be contained inside the act, you put them in a schedule, but the schedule must be tied to a section of the law. Schedule to section 20, procedure for board meeting, governing board meetings. Schedule to section 21, procedure for appointment of director general. Schedule to section 22, procedure for termination of appointment of director general. All right, somebody else can volunteer. There are other components of administrative provisions. Can you come up with them?
Yes, Madam Uju, I had called you before Joyce volunteered. Yes, you may proceed, ma'am.
Okay, sir. So I want to take
Yes.
number 3. Number C.
Yes.
I understand to mean that
Go
the
ahead, please.
powers, qualification of the chief executive and other principal members, the mode of appointment and determination should be specified.
Okay, so what will happen if you do not specify the qualifications?
Anybody can assume that office if it's not specified.
So for those of you in Lesotho, I always make a practice. You learn a lot when you buy the newspapers. Every day I buy your newspapers. So this is Lesotho Times. The front page says new DG, Director General of Directorate of Corruption, Economic Offences. The boss resigns. This is the Lesotho Times. I bought it today. Now, the law says whoever shall be the Director General of this anti-corruption agency shall be a legal practitioner. The former person that just resigned, the Law Society of Lesotho said his name is not on the roll of legal practitioners, so he does not meet the qualifications as specified in that establishment law. Now, a new person was appointed he's an army officer. The Law Society also wrote again that for you to be qualified as part of the qualifications, you must be a legal practitioner. You cannot be a soldier and still say you are on secondment. So he did not meet the qualification. So he had to resign from the army so that he would focus on this job. That's the power of having qualifications into your laws. It must be written as part of the administrative provisions. Otherwise, you have a situation where any and everybody can be made the Director General of the anti-corruption agency. And it defeats the purpose, because an anti-corruption agency is a serious agency of government. And the person who heads it must be above board. It's not any and everybody. You cannot be headed by a politician, because a politician would help their friends to escape corruption. So, in drafting the administrative provisions, you have to specify the qualifications of the persons that you want to hold that position. That is what has happened in real life. The Law Society could only go to court because these qualifications were stated in the law. If they were not stated in the Law Society couldn't have gone to any court. No court will listen to them. But because the establishment law contains these requirements, that is why the Law Society could go to court. So you can see the drafters of these laws took time to provide the qualifications. So drafting is not something you just rush. Now there's another, I read in the newspaper, something else is happening now. There's, under the 1983 Legal Practitioners Act of Lesotho, there's a section 6 that says that if you want to qualify as an advocate, there should be an exam. So this is the paper. A graduate of NUL has gone to court to say this provision cannot apply. Because if you want to apply this provision, the Chief Justice of Lesotho also has to write the qualifying exam before he can be declared an advocate. So this is what happens when you create qualifications, conditions under administrative provisions. All right, any other person? Ebenezer, are you there?
I'm here, sir. I'm here. Okay, we have a hand up. Please go ahead.
Most times, if you run an update, I never run an update for this one. That policy might come.
Yes, proceed.
Ebenezer, you are the one raising your hand.
Oh, sorry, sir. Sorry. Okay. Who do I call now? Do you have any other volunteer? Okay.
Which one is available? I can take the next one. Is it
No,
F
D.
now?
D.
Okay, D, procedures for meetings of the governing board. Okay, so that would be how the meetings are supposed to take place, how notices are to be sent out, and how the reports, how to conduct the meeting in the event of maybe the absence of the chairman or whoever is supposed to preside, what happens. It also deals with, I think, the quorum to be formed before meeting would start. That's what I understand by that D.
And this is a very important part of you will not realize how important. For example, how decisions are made. A quorum, let's say the governing body, I told you, normally 6 representatives. It may be more than 6 because outside the 6, you have representatives of other institutions. Now, let's say it's 12. This procedure must set out what is quorum. Out of that 12, it should be 5. So you need a quorum of 5 for any decision that will carry the force of law. If it's less than 5 members that met and did that meeting, that means no decision was reached. These are very, very important procedures because it's as if the drafters of the law, even the lawmakers, envisage that once in a while there will be conflicts. And there will never be a time when everybody may agree on something. But what is the minimum number you need to carry a decision? Very important. I've been on the board of a federal government agency and I know what's quorum. Very important. Very important. And procedure for meeting. Who calls the meeting? The secretary. How does he notify? It could be in writing. It must be in writing, not it could be. It must be in writing. It's not phone call. So all these procedures, they are very, very lengthy. You now need to put them in a schedule to the section. All of them cannot be contained. A schedule to section 5 for the procedure for board meetings, governing board meetings. Very important. Very important. Okay, who wants to try the next?
Next. Any other volunteer? Okay, let me call. Little Boho, can you try? Tete, can you try?
Yes, sir.
Okay, please try.
It's number E.
It's just an
Functions of
attempt.
yes, sir. Functions of the supervising
You may
minister.
proceed, sir.
Yes, sir. My understanding is that under this provision, the law must clearly state to what extent shall the minister be involved in that agency. Like, under which circumstance can the minister dictate the direction of the agency? Is the agency independent? In what circumstances can the agency be accountable to the minister? I want to believe it has to do that the provision has to state clearly the parameters of the supervising minister.
Thank you. I like the use of the word parameters. You remember what you said. Power corrupts. Absolute power corrupts. Absolutely. So you must, when we studied how to prevent corruption through legislative drafting, whenever you grant powers to anybody, you must also create the parameters for exercising that power. You cannot just give somebody powers of discretion and say, he's a good man, I think he will behave well. No. Power has a corrupting influence. So the only remedy, antidote, is you create the parameters for exercising that power. So that if he abuses that power, the law shows that he has abused it. For example, the power of the minister in any government is to nominate who will be the head of that agency. So yes, that's the power to the minister. But you cannot give that minister the power to sack the person he has nominated. The minister will nominate, then the prime minister and the king will confirm the appointment. But you cannot give them the minister the same power to fire at any small thing. It must also go through the same process. If the minister is dissatisfied with the performance of the head of the agency, he needs to also write to the parliament or the prime minister stating grounds for termination. Then the parliament will vote and say, okay, we are satisfied that the minister has given cogent reasons. Based on that, there's a vote and then the person goes. So everything has to follow laid down procedures, parameters, so that people behave within the confines of sanity. Yes, Madam Uju, you were raising your hand.
So sorry about that. It was a mistake.
So if you don't do that, that is where you find ministers and heads of agencies are always fighting, because the establishment law did not specify the functions of the minister. So these are important things under administrative provisions. Any other questions? Okay, carry on, Ebenezer. Ebenezer. Okay, who wants to take the next part? Yes? Who wants to take after functions of the supervising minister? Who wants to take the next one? Hello? Check the chat box. Yes, Umaru, Hannah.
Okay, Hannah. Hannah, your hand is raised. Hello, Hannah.
Yes, I can hear you. Good afternoon, sir. Good
Yes,
afternoon,
good
Prof.
afternoon. Go ahead with your question.
Okay, my understanding of number E talks about the financial provisions relating to the
Number
said
F,
statutory
not E.
Oh, okay. Okay. Financial, sir, is it? I think it was EF, okay, right. The financial provisions relating to the said statutory corporation, such as submission of annual financial reports. For me, I believe this is talking about the income and expenditure of the agency in question. So they have to submit all the reports, how they get their income, how they spend their income. All these things must be done annually. Then the one in bracket that says, as well as any other transitional regimes. For me, I feel like this means that in a situation whereby there is like an interim director general, so to speak. So what are the powers of that director general in the interim, pending when a substantive head of that corporation will be appointed? What are his powers? To what extent does he have to exercise his powers? That's my understanding of paragraph
Thank you.
F.
You're correct. The source of income of every federal government agency must be stated. Is it the Consolidated Revenue Fund, or are they allowed to invest funds of that agency in bank bonds, treasury bills, and make money? So that is what you need to specify. Everything must be in black and white. How will this agency generate funds? So everything has to be specified. Now, transitional means, yes, you are right. But another scenario is there may be an agency coming to take over from an existing agency. Transitional means in the interim period, what arrangements? Like what you said is very true. Look at what is happening online in Nigeria. Nnamdi Azikiwe University expelled a student. Yes, she committed a crime by fighting her lecturer. Now, the problem there is the vice chancellor is an acting vice chancellor, and there's a limit to powers that an acting vice chancellor can exercise. Only a governing council can approve expulsion. Now, this acting vice chancellor has approved expulsion of this student because she does not know, or he or she does not know, the limits of her power as an acting vice chancellor. So this is where your law, your administrative provision will state, in the event that there is an acting chief executive, there is a limit to the powers he can. The reason is so that acting people will not go and bind the organization with financial obligations. So there needs to be administrative provisions for transitional arrangements. You don't leave it to chance. Oh, I'm thinking this acting chief executive, his brain, he's a normal person, he will think well. No, people don't think well. When power enters anybody's hands, they don't reason well. Okay, any other thoughts, any questions? Any questions?
Any questions? We just have less than 2 minutes to the end of the class, actually. That we have gotten to more practical aspects, because if you follow the trajectory of the timetable and the lecture, it has been a build-up, one layer upon another, one layer upon another. Now, the topic we are treating, we started last week, is the core of legislative drafting. The core, the practical aspects. We have done preliminary provisions. The whole of this week, tomorrow, next, till Friday, we are going to be dwelling on principal provisions. And please understand that principal provision is the core of your bill or your law. If you do not get your principal provisions right, you will be setting a foundation for confusion in implementation. It's not as if one area is more important than the other. No. But you have to get any mistake in any of the sessions is going to lead to trouble because they are all interconnected. So any question before we end today's session? Okay, your hand is up. Please ask your question. Hannah. Hannah, ask your question.
No, sorry, sir. It was my answer was
Okay, the previous one. Okay. Thank you very much. Okay, in the absence of any other question, we will be coming to the end of today's session. However, there is an assignment for this week. Check the WhatsApp platform. You will see the assignment for this week. The widowhood leave bill is there. Read the instruction for the assignment. Fill in the gaps, the areas or the preliminary provision clauses that were left out by the drafter. So fill them in. You have between now and Friday, the whole of this week, in fact, up to Saturday to submit. So take your time. Then I will also encourage you, the Communications Act is there. Please download it. It is a perfect example of a comprehensive bill, a comprehensive act law that has all the 4 parts intact. Please, just look at that Nigerian Telecommunications Act. Download it, study it, familiarize yourself with it, see how they put everything in order. So, thank you very much. See you tomorrow by 12. Sorry I could not participate much. I am at a place they are fixing some stuff for me. Hopefully tomorrow I'll be in the office and we engage more. Thank you.
Thank you, Prof. Thank you, Mr. Ebenezer.
Thank you.
Bye, everyone.
Thank you.